We've all been there, right? Stuck dealing with some frustrating bureaucracy. But what happens when a simple request for information turns into a full-on legal battle? Well, that's what we're diving into today. It's a classic David and Goliath story. One homeowner, their HOA, and a fight for transparency that, honestly, has some big lessons for all of us. Seriously, have you ever asked for something you knew you had a right to and just got nothing? A total wall of silence? That is exactly what happened to homeowners John and Debborah Sellers. Their journey is more than just a story. It's kind of like a playbook for any of us who've ever felt totally powerless going up against a big organization. All right, so let's set the scene. We're in the beautiful community of Prescott, Arizona, and we meet John and Debborah Sellers. Now, they were active members of their homeowners association, but they started to have some questions. Like, hey, where's our money going? How are these big decisions being made? So they did what you or I would do. They just asked to see the records. And this right here? This is the spark that lit the whole fire. On January 29th, 2015, the Sellers sent a formal email. Not a casual phone call, but a documented written request. The law gave the HOA 10 business days to respond. So the clock starts ticking. 10 days go by. And crickets. Nothing. That's when the Sellers knew, okay, we've got to escalate this. And just look at the precision here. This subject line itself, records, copy, requests, is so clear. This wasn't some casual question. This was a serious formal request. And this one single email, it became the absolute cornerstone of their entire case. It's such a powerful reminder. In any kind of dispute, that paper trail is your best friend. So what were they actually asking for? Well, it wasn't some huge fishing expedition. It was a targeted set of documents that would shed some real light on the HOA's operations. Things like a legal affidavit, an insurance policy, competing bids for management companies. The kinds of records any member should be able to see in the name of transparency. So the Sellers send this perfectly reasonable request. How do the HOA respond? Not with transparency, that's for sure. They responded with a big ol' wall of excuses. And this is the point where a simple request for information just spirals into a full-blown conflict. Honestly, the HOA's defense was a masterclass in deflection. Their arguments all boil down to one of three things. It doesn't exist, we don't have it, or the classic, we already gave it to you. But as we're about to see, these simple excuses really started to crumble under a little bit of scrutiny. This table just captures the absurdity of the whole situation. For that legal affidavit, the HOA said it's not in our possession, but then admitted they never even bothered to ask their own lawyers for it. The manager's report was supposedly blank until, whoops, actually it had bullet points. Competing bids? Oh, those were conveniently destroyed. And the insurance policy? They didn't have it until they suddenly did. You start to see a pattern here, and it's pretty hard to ignore. But the Sellers were not backing down. Faced with this complete stonewalling, they realized they had to take the fight to the next level. They decided it was time to use the power of the law to get the answers they deserved. And this next step, well, it required a real commitment. To even get their case heard, the Sellers had to put their own money on the line, a $550 filing fee. So this wasn't just about a few documents anymore. It was about investing in the principle of transparency itself. And here's the thing. The Sellers had the law on their side. A specific Arizona statute lays out the rules of the game very clearly. HOAs have 10 business days to provide records. It's a simple, clear-cut rule that's designed to protect homeowners. The only question was, would the judge agree that the HOA had broken it? So the stage was set for a showdown. On June 17, 2015, the Sellers and their HOA faced off in a formal hearing. Both sides laid out their arguments, and it was all up to an administrative law judge to decide who was right. Now, before we get to the verdict, there's this key legal concept to understand. It's called preponderance of the evidence. It sounds complicated, but it's not. It just means the Sellers had to convince the judge that it was more likely than not that the HOA broke the rules. Think of it as just tipping the scales past 51%. So what was the verdict? It was a partial but very important victory for the Sellers. The judge found that the HOA had violated the law on 2 key counts. That we don't have an excuse for the affidavit. It didn't fly, especially since it was sitting with their own lawyers. And the argument that the manager's report wasn't useful, the judge said that was totally irrelevant. It was a record, and the Sellers had a right to see it. While they didn't win on every single document, the core principle was established. A record being accessible is not an excuse for secrecy. And this victory wasn't just symbolic. The judge ordered the HOA to hand over the documents within 10 days. And in a final act of justice, they were ordered to refund the sellers $550 filing fee. The message was crystal clear. If you try to stonewall homeowners, it will cost you. The sellers' persistence had paid off, literally. So, the sellers won their battle. But what about the bigger picture here? What can we all learn from their fight that we can apply in our own lives, whether we're dealing with an HOA, a big corporation, or even a government agency? Here is your playbook. First, and this is huge, document everything. A written request is your foundation. Second, don't take "we don't have it" as a final answer, especially for records they can easily get. Third, remember that an organization's opinion of why you want the info is irrelevant. If you have a right to it, you have a right to it. Fourth, know the rules and the official channels for appeal. And finally, be persistent. As the sellers proved, a little bit of grit can go a very long way. You know, the seller's story is a powerful reminder that the right to information is only as strong as our willingness to fight for it. So the next time you're faced with a wall of silence, you have to ask yourself, are you just going to accept it? Or are you going to be the one who demands answers? The choice is yours.